We'll discuss patents and trademarks today, which are two types of intellectual property. What is intellectual property? Intellectual property, IP, refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names and images used in commerce. There are four categories of intellectual property, two of which are trademarks and patents. Patents are classified into three types: utility patents, design patents, and plant patents. What is a patent? A patent is an exclusive right granted for an invention, which is a product or process that provides. Patents are grants provided to inventors that allow them to control the manufacture, use and sale of their inventions. Utility patents may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement, also known as a patent for invention. A plant patent protects a new and unique plant's key characteristics from being copied, sold, or used by others. A design patent, on the other hand, protects the distinctive appearance of a manufactured item. Consider a vehicle with a distinctive hood or headlamp shape. These visual characteristics contribute to the car's identity and may increase its value. Republic Act No. 8293, or the Intellectual Property Code of the Philippines, IP Code, is a patentable invention is any technical solution in any field of human activity that 1. Is new, 2. Involves an inventive step, 3. Is industrially applicable. Patent protection is not extended to some categories. 1. Scientific theories, discoveries, and mathematical approaches. 2. Schemes, rules, and procedures. 3. Methods for treating the human or animal body through surgery or therapy, as well as diagnostic methods. 4. Plant varieties or animal breeds, or essentially biological process for the production of plants or animals. 5. Aesthetic creations. 6. Anything contrary to public order or morality. Which authority registers patents? Does it have guidance on the application procedure? The Philippine Intellectual Property Office, IPO, registers patents in the Philippines through the Bureau of Patents. The procedure is found on their website. How long does a patent last? A granted patent has a duration of 20 years from the filing date of the application. Patent principles. 1. Territoriality. Patents are only valid in the country or region in which they have been granted. 2. First to file applicant who files first will get the patent. 3. Disclosure applicant shall disclose the invention in a manner sufficiently clear and complete. 4. Quid pro quo principle, protection in exchange for disclosure. 5. Conditional, patents are granted only upon compliance with the criteria of patentability. On what grounds can a patent infringement action be brought? Which courts deal with patent infringement actions? The grounds for an infringement action are the unauthorized making, using, offering for sale, selling or importing of a patented product or a product obtained directly or indirectly from a patented process and use of a patented process. It is filed with the IPO and further appeals are brought to the Court of Appeals and then to the Supreme Court. What are the defenses to patent infringement actions? The following defenses can be raised: invalidity of the claim, existence of a ground for cancellation of the patent. What are the remedies in patent infringement actions? First, administrative proceedings. Second, civil proceedings, and third, criminal proceedings. What are the legal conditions to obtain utility model protection? It should be new and industrially applicable. On what grounds and when can third parties oppose a utility model application? The grounds for the opposition/cancellation of a utility model are any of the following. The utility model is not new or industrially applicable. Next, is the utility model is not registrable, and the subject matter of the model extends beyond the content of the application as originally filed. Republic Act No. 8293, 1997, and Republic Act No. 10372, entitled an Act amending certain provisions of Republic Act No. 8293, otherwise known as the Intellectual Property Code of the Philippines, and for other purposes, 2013. Trademark. What are the legal requirements to obtain a trademark? The IP Code defines a mark as any visible sign capable of distinguishing an enterprise's goods or services. This includes a stamped or marked container of goods. A mark must be registered with the IPO to be protected. Is it necessary or advisable to register trademarks? Registration is necessary for protection against trademark infringement. In any event, an action for unfair competition or passing off may be brought by the proprietors of unregistered marks. Which authority registers trademarks? The IPO registers trademarks through the Bureau of Trademarks. On what grounds and when can third parties oppose a trademark application? Any person who feels that the registration of a mark might cause them harm or that the registration is illegal may launch an opposition or revocation action. An opposition can be submitted within 30 days after the trademark application's publication. Cancellations may be filed at any time after the grant has been made. How long does trademark protection last? The term of protection is 10 years from grant, renewable for periods of 10 years. To maintain the registration, declarations of actual use, DAOs, and evidence of use must be filed. What are the defenses to trademark infringement actions? Common defenses include that the mark involved does not cause the likelihood of confusion or mistake in the mind of the public, or deceive purchasers as to the origin or the source of the goods. Lack of prior registration of the challenging mark is another defense. Some of the trademark prosecution are as follows. First, ownership of trademarks should be a natural or juridical person who is using or intends to use in commerce a mark in connection with goods and/or services. Second, the registration timeframe of 8 to 10 months from filing date. Third, types of applications are divisional application and multi-class application. Lastly, opposition period is 30 days. Some of the trademark enforcement are as follows. Criminal penalties are imprisonment, 2 to 5 years, or fines, from 50,000 pesos to 200,000 pesos. With a timetable of trial for 1.5 years and appeal 1 year. Remedies are doubled damages, with showing of actual intent, impoundment of documents evidencing sales, disposal of infringing goods, removal of infringing trademark, and injunction.